You have the floor, Madam.
Mr. President, Madam Vice President, members of the court, it is a special honor to appear before you today on behalf of the Republic of Namibia. With your kind indulgence, I wish to first pay tribute to our late President, Dr. Hage Geingob, who passed away on 4 February 2024 and will be laid to rest this weekend. President Geingob was a key figure in our struggle for independence. He was a committed anti-apartheid and anti-colonial freedom fighter who stood up against injustice and oppression wherever it occurred. It is therefore fitting that in one of his last public statements, he said that no peace-loving human being can ignore the carnage waged against Palestinians in Gaza. President Geingob was the representative of SWAPO and its petitioner to the United Nations from 1964 to 1971. It was during this period that the General Assembly condemned and declared the policies of apartheid and racial discrimination as a crime against humanity. Consequently, the General Assembly also appropriately terminated the mandate in Southwest Africa. Mr. President, members of the court, I stand before you as a representative of a country where Germany brutally carried out the first genocide of the 20th century against the Herero and the Nama peoples. A country that has known only too well the pain and suffering of occupation, colonialism, systematic discrimination, apartheid, and their entrenched consequences. It is because of this history that Namibia considers it a moral duty and sacred responsibility to appear before this court on the question of the indefensible occupation of Palestine by Israel. The parallels between Namibia and Palestine are striking and painful. Both were integral parts of the mandate system established after World War I, and in both cases, the so-called sacred trust of civilization, which aimed to guide these nations towards self-determination and independence, was utterly betrayed. Instead of achieving self-government, both Namibians and Palestinians suffered the loss of human dignity, life, liberty, and the outright theft of their land and natural resources. Hundreds of thousands of their people were violently expelled from their homes or forced into exile, joining the ranks of the world's refugees. Upon the dissolution of the League of Nations in 1946, the white minority South African regime refused to place Namibia, then Southwest Africa, under the UN trusteeship and sought to illegally annex our territory as a fifth province, implementing racist homeland policies and apartheid laws targeting Black Africans. Today, Palestinians have had to endure the seizure of their land and property, illegal settlements, unlawful killings, forced displacement, drastic movement restrictions, the denial of refugees' right to return, and of equal nationality and citizenship. The lived reality of the people of Palestine evokes painful memories for many Namibians of my generation. Namibians still experience the entrenched and structural impact of inequality as a direct consequence of colonialism and the prolonged unlawful occupation. Mr. President, members of the court, this court's 4 advisory opinions on Southwest Africa played a vital role in our liberation struggle. In its 1971 opinion, the court confirmed the right of self-determination as a legal imperative with decisive consequences for states, paving the way for our independence 19 years later in 1990. It is because of Namibia's experience with apartheid and its long fight for self-determination that we cannot look the other way in the face of the brutal atrocities committed against the Palestinian people. Mr. President, members of the court, we ask you not to look away either. Rather, we appeal to you, once again, end the historic and ongoing injustice by upholding the fundamental rights of a dispossessed people who have endured 57 years of a suffocating occupation. Today, Palestinians are enduring collective punishment in the besieged Gaza Strip, with civilians being killed in continuous and indiscriminate bombardments at a scale that is unprecedented in recent history. This state of affairs, this hell on earth, represents a stain on the collective conscience of the world. Civilized nations cannot and must not accept images of children covered in blood with gaping wounds, of men and women crying in despair because of the helplessness they feel. However, in the midst of the ongoing tragedy, I wish to say the following to the people of Palestine. This advisory opinion is an important moment in your long fight for independence. And I leave you with the words of our founding president and father of the Namibian nation, Dr. Sam Nujoma. A people united, striving to achieve a common good for all members of society, will always emerge victorious. End of quote. Mr. President, members of the court, I thank you, and I now respectfully ask that Professor Phoebe Okoa be called to address the legal questions before the court.
I thank Mrs. Dosab. I now give the floor to Professor Phoebe Okoa. You have the floor, Professor.
Mr. President, Madam Vice President, members of the court, it's a great honor for me to appear before you in these proceedings and a special privilege to do so on behalf of the Republic of Namibia. Our presentation is in 3 parts. First, I will make 2 general observations on why the court should answer the request in its entirety and why Israel's occupation is illegal. Then I will focus on Israel's policies and practices in the occupied Palestinian territory that grossly violate its obligations under international law, specifically the prohibition of apartheid and racial discrimination and the principle of self-determination. Finally, I will address the legal consequences that arise for Israel, for third states, and for the United Nations on account of these violations. As a threshold matter, Namibia reiterates, as do the overwhelming majority of states in these proceedings, that the court has jurisdiction to render the requested advisory opinion and that there are no compelling reasons for the court to decline the request. Namibia notes that there is also wide consensus among the participants on the legal status of the occupation. Namibia makes only 4 brief observations. First, insofar as the law of occupation envisages any belligerent occupation as a temporary measure immediately following military operations, Israel's prolonged or permanent occupation breaches the law of occupation. It is a de facto annexation in all but name. Second, Israel's occupation in and of itself is unlawful under general international law. This is because it violates the Charter of the United Nations and peremptory norms, specifically the prohibition on territorial acquisitions through illegal use of force, the principle of self-determination, and the prohibition of apartheid. Third, successive resolutions of the Security Council and the General Assembly have declared Israel's occupation to be illegal and called on Israel to end it immediately. These resolutions provide an independent source of authority for the illegality of the occupation. Finally, the continuation of the illegal occupation does not absolve Israel from its obligations and responsibilities under international law. This is consistent with your own conclusions in the Namibia Advisory Opinion that physical control over territory and not sovereignty or legitimacy of title is the basis of state liability for acts affecting other states. In both its written and oral submissions, Namibia focuses on the prohibition of apartheid and of racial discrimination. This is in part on account of Namibia's history as one of the few countries that was subjected to this egregious form of systematic and institutionalized racial discrimination. We also do so on account of the fundamental importance of the court's 1971 Namibia opinion, where this court declared that the policies of apartheid constitute a denial of fundamental human rights and are a flagrant violation of the purposes and principles of the United Nations Charter. But above all, we do this because, notwithstanding the egregious nature of apartheid as a state delict, as a violation of a peremptory norm, and as a crime, it has received virtually no clarification beyond the specific circumstances of Southern Africa. An advisory opinion on threshold questions of apartheid will therefore assist the General Assembly in respect of its own action in identifying the key elements of the illegality and in formulating appropriate responses to Israel's discriminatory practices in the occupied Palestinian territory. Specifically, we invite the court to clarify 3 aspects of the obligation. First, we respectfully ask the court to make it clear that the prohibition of apartheid is not limited to Southern Africa in the last century. It extends to Israel's policies in the occupied Palestinian territory today. Article 3 of SAD places all state parties, including Israel, under an obligation to prevent, prohibit, and eradicate apartheid in territories under their jurisdiction. This is also the conclusion of the SAD Committee. The 1998 Rome Statute of the International Criminal Court, negotiated after the end of apartheid in South Africa, also recognized apartheid as a crime against humanity without temporal or geographical restriction. Second, the court should also confirm that the prohibition of apartheid binds all states as a peremptory norm. In your decision, in the case under SAD brought by Qatar against United Arab Emirates, you acknowledged the universal character of SAD is confirmed by the fact that while 82 states are parties to it. The International Law Commission and its Special Rapporteur on Youth Cogents, as Judge Tladi then was, has also expressly recognized the peremptory character of the prohibition of apartheid. Finally, Namibia invites the court to clarify the definition of apartheid. Namibia aligns itself with other participants that the definition in Article 2 of the Apartheid Convention incorporates the three key elements of the delict under international law. First, the state must engage in one or more inhumane acts. Crucially, these take the form of violations of fundamental human rights within an institutionalized framework of systematic oppression and domination. Second, these inhumane acts must be directed against a racial group or its members. Finally, the state must commit these inhumane acts for the purpose of establishing and maintaining domination by one racial group over the other and systematically oppressing them. Other participants have already made extensive statements on the discriminatory and inhumane acts carried out against the Palestinians as a racial group. These policies and practices are too many to enumerate in the time available. They include laws that discriminate in matters of citizenship, ownership and transfer of property, and freedom of movement. The systematic and excessive use of force against Palestinian civilians, the arbitrary killings and mass incarceration of Palestinians, including children, the illegal settlements, the discriminatory residency regulations, and crucially, the denial of a Palestinian identity by refusing to recognize them as a people with a right to determine their own political destiny and to pursue social, economic, and cultural development. Namibia's submission will focus on the final requirement, the purpose of establishing, maintaining domination and systematic oppression. First, the term domination signifies a pervasive, all-encompassing, serious form of control over a group. Second, oppression implies prolonged cruelty reflecting a sustained violation of human rights. Third, systematic implies the organized nature of violent acts and the improbability of their random occurrence. Namibia shares the view of other participants that Israel's policies and practices meet the evidentiary standard for establishing the state delict of apartheid. The Israeli government's openly articulated aim is to ensure Jewish Israeli control of all facets of Palestinian life, as evidenced by legislation affirming Israel as the nation-state of the Jewish people with unique self-determination rights reserved for Jewish individuals only. It is clear from all the available evidence that these discriminatory practices are not accidental or fortuitous, but are designed for the specific purpose of privileging Jewish Israelis over Palestinians. The fact that the practices in question may have other collateral objectives, such as maintaining security, is irrelevant. It will suffice if the primary motive is discriminatory, even if it also serves ancillary purposes. It follows in Namibia's submission that Israel's policies and practices are inconsistent with the prohibition of apartheid as a state delict under international law. Furthermore, these discriminatory practices in the context of prolonged occupation of the Palestinian territories violates the right of the Palestinian people to self-determination. As other participants have highlighted, these discriminatory policies and practices are directed at fragmenting the Palestinian people. These elaborate systems of administrative controls undermine group cohesiveness by dividing the Palestinian people into a number of administrative domains or groups with varying degrees of rights. This strategic fragmentation of the occupied Palestinian territory into Bantustans makes Palestinian life burdensome and in many cases unbearable, forcing them to leave their homes. Perhaps the epitome of discriminatory laws negating the Palestinian right of self-determination is the 2018 Basic Law, passed with constitutional status, which boldly declares that Israel is the nation of the Jewish people and that Jewish settlement is a national value. I will now turn to the final part of my submission. I will first examine the legal consequences of Israel's violations, irrespective of the status of the occupation. Second, I will examine the legal consequences arising out of the illegal status of the occupation. First, Israel must bear consequences for its violations. This is the most elementary requirement of the law on state responsibility. As others in these proceedings have highlighted, this includes the obligations of secession and the duty to make reparation for more than 5 decades of harms inflicted on the Palestinian people. The government of Israel has a legal duty to dismantle all the vestiges of systematic racial discrimination and oppression that permeates all aspects of Palestinian life in the occupied territories. As the State of Palestine itself said on Monday, Israel must bring to an end the annexation of Palestinian land, dismantle existing settlements, and recognize the right of the Palestinian people to self-determination in a viable state of their own. Second, states are under an obligation not to recognize Israel's breaches of peremptory norms of general international law vis-à-vis the Palestinian people. At the same time, the obligation of non-recognition is matched by a parallel and positive duty of recognition of the Palestinian people's right to self-determination realized through a viable and independent state of Palestine. Here, we ask the Court to pay particular attention to the historical context of these proceedings. Admission to the United Nations, unlike the League of Nations, was not automatic. It was conditioned on the state accepting to uphold the values and principles contained in the Charter, including self-determination. The admission of Israel was no exception. In the Wall opinion, you observe that when Israel proclaimed its independence, it did so on the strength of the Partition Plan resolution of the General Assembly. As is well known, that plan envisaged 2 states, one Arab and one Jewish. The Israeli Declaration of Independence makes this plain by recognizing, and here I quote, the natural right of the Jewish people to be masters of their own fate, like all other nations, in their own sovereign states, unquote. If that logic applied to the self-determination and statehood of the Jewish people, it must, by the same token, also apply to the self-determination and statehood of the Palestinian people. We further ask the Court to consider whether there may be circumstances where political discretion in matters of recognition gives way to a positive duty of recognition, especially when it is necessary to safeguard a peremptory norm. And here, Namibia aligns itself with Jordan's written submission that all states are also under an obligation to recognize the right of the Palestinian people to self-determination, including by exercising that right within a viable and independent state of Palestine. Since Israel's policies and practices violate peremptory norms of international law, the occupation itself is unlawful. This entails consequences for Israel, for third states, and for the United Nations. In the Namibia opinion, you already set out the legal consequences of unlawful occupation. There, you said that once the court is faced with an illegal situation, it would be failing in the discharge of its judicial functions if it did not declare that there is an obligation, especially upon members of the United Nations, to bring the situation to an end. In that opinion, you recognize the clear obligation on South Africa to put an end to the illegal occupation and withdraw its administration from the territory. The same consequences must of necessity attach to the illegal occupation by Israel of the Palestinian territories. Secession cannot be contingent on external factors such as the successful outcome of negotiations, as pointed out by some participants in these proceedings. A withdrawal contingent on the outcome of political negotiations effectively gives Israel a veto over the future of the Palestinian people. Namibia invites the court to set a strict time limit within which Israel must be asked by the General Assembly to bring the occupation to an end without conditions. Failure to set a strict time limit has the perverse effect of being treated as acquiescence in the present occupation and permission for it to continue indefinitely. Of course, Israel has defied this court and ultimatums issued by the United Nations organs many times. But it is precisely for this kind of egregious violations of peremptory norms that a regime of countermeasures was contemplated in the now widely accepted International Law Commission draft articles on state responsibility. Equality before the law is a cardinal principle of the United Nations Charter. No state, not Israel, should be exempt from the comprehensive regime of sanctions. Moreover, Namibia reaffirms the position held by the majority of participants that all states are under an obligation not to recognize, assist, support, or contribute to the continuation of the unlawful occupation. This is also in line with your own settled jurisprudence. In the Wall opinion, you confirmed that obligations of third states include the obligation not to render aid or assistance in maintaining the illegal situation, that all states must refrain from all forms of assistance, including transfer of arms and political support that de facto perpetuates the occupation. In Namibia's view, this means, in particular, that all states are under an obligation to ensure that companies under their jurisdiction or control do not trade in Israeli goods or with Israeli companies originating from or linked to Israel's illegal occupation. Mr. President, members of the court, I thank you for your kind attention. This concludes Namibia's oral submissions.